If there is a legitimate expectation of privacy, the Fourth Amendment to the United States Constitution permits searches and seizures that are considered reasonable if there is probable cause that evidence of commission of a crime will be found. Most searches conducted by law enforcement require that a search warrant be issued by a court of law prior to the commencement of the search. However, a particular set of circumstances may legally justify a warrantless search, including but not limited to the following. When a person in control of the property agrees or consents to the search. When evidence or contraband is initially seen by law enforcement officers because it is in plain view. When the search is incident to an arrest. Upon making a valid arrest, a police officer may conduct a search that is limited in scope to the defendant's person and areas within the defendant's immediate control. The purpose is for the self-protection and to locate evidence that the suspect may attempt to destroy. When law enforcement conducts a limited search of a person to assure the officer's safety, a Terry stop or stop and frisk occurs. A police officer who has a reasonable suspicion of criminal behavior to stop and question someone may, for purposes of self-protection, perform a limited pat-down of the person, which is called a frisk, to identify possible weapons or other contraband. When an emergency or exigent circumstances exist and the time involved in obtaining a search warrant would pose a threat to public safety or lead to the loss of important evidence through its destruction by a potential defendant. When an emergency or exigent circumstances exist and the time involved in obtaining a search warrant would pose a threat to public safety or lead to the loss of important evidence.